For the last 2 decades, that's how old the collegium system is. We never knew much about how judges were appointed, and now, since Supreme Court struck down the government's proposal of having a commission for appointment of judges, they also accepted that yes, their system needed improvement, needed transparency. And so, when Supreme Court met today, they looked at various suggestions. The government came out with lots of suggestions, and on agenda today, we have one of the senior most advocates, Anil Devan, joining us, who was also in court arguing there, giving his suggestions of how the collegium should change. We also have Gopal Nariman, who's joining us, who has a different take on the entire thing. And we'll talk about why is it that it's taken so long? Like, did you know that even now there is no set criteria, or at least a criteria that's been made public about what qualifications a judge should have? So today, my colleague Arunachalam Vaidyanathan reports on what are some of these suggestions that came up in court. Take a look.
Judges will still appoint judges, but with a little more transparency. The Supreme Court has appointed a 2-member panel to go through the many suggestions given to improve the existing collegium system.
They have asked us to collate all these suggestions and tabulate them into 4 categories. That is transparency, eligibility criteria, on the question of the secretariat, and on complaints.
Top legal luminaries from Fali Nariman to Rajiv Dhawan to Gopal Subramanium have suggested more openness and discussions by the collegium in appointing judges, and the government is supporting them.
Everybody should have a right to be considered, and the best should be selected in the process. So these are the 2 criteria, and the third paramount consideration is transparency.
Though the Supreme Court is trying to make amends by ensuring a transparent judges appointment system, but it has ruled out a complete wholesale change in the existing collegium system. The Supreme Court will examine the suggestions made by the petitioner and the government on the 5th of November. In New Delhi, Arunachalam Vaidyanathan, NDTV.
The court had appointed Additional Solicitor General Pinky Anand to go through these suggestions, and she was supposed to be on the show, but we've just been told that she's now been called back by the judges for a discussion on that. So we have Anil Devan over here, who was also arguing in court. So what are some of the suggestions that you told the court about how they could improve the collegium system?
The first thing I want to say is that we have won, but I must appreciate the stand of the Attorney General and the government in extending full cooperation while not accepting the correctness of the judgment. I think that's the right spirit in which we have started this discussion of cooperation by which we can improve the system. Now, 2 or 3 things which I suggested and which I think should be very seriously considered are these. First and foremost, for High Court appointments, there should be an application or a nomination or an expression of interest by people who are interested and agreeable to become High Court judges. Secondly, they must give information about themselves, their CV, their income, their experience, whether they have written articles or not, academics, all sorts of things. And in that way, this should be put on the website so that people know who are interested in taking up a High Court judgeship, number 1. Secondly, there has to be a filtering process, a process by which you arrive at a short list. And how do you arrive at a short list would depend on the criteria which the Supreme Court will now deliberate upon. And those criteria again must be not only subject to discussion, but must be put in the public domain. I think this will ensure an enormous amount of transparency, and the right to know of the people would also be met.
So I have a young lot of students over here who are all law school students, and I was just asking them, some of the things that people has been suggested in court, that you can't have that much transparency, and none of these people could actually comprehend the fact that too much information or transparency could be a bad thing. And that's what I want you to talk about, Gopal Nariman. The fact that Anil Dewan had to suggest to the court something all of us in any other jobs take for granted, that you would have to put your CV there, you would have to make the criteria public. Why is that such a mystery in the courtroom among judges?
Well, I think that's one of the issues that the judges themselves, when they delivered the judgment, were aware of. And they realized that the biggest criticism when this matter went on for so many days, more than 30 days, the arguments that were being made on behalf of Mr. Dewan and his colleagues was primarily on the fact that apart from the constitutionality and legality, that in practice you have names being suggested behind a thick curtain. You don't know why those names were suggested, you find opposition to it, and you find those names being passed. So there is no larger consultation that takes place as far as the people who are being considered goes. It's this restricted little collegium of judges, and they basically, and the impression that is created is that a kind of coterie is being built. So I think the judges understood that. So many of the judges in their judgments have said that, look, they've used words like glasnost and perestroika, trying to open up the system. And therefore, I think it's a good thing that they've set it down today to understand what are the steps that need to be taken to improve the collegium and make it more transparent. But the danger, I feel, of making it too transparent is that, for example, these individuals who apply then to become judges, you will suddenly find all sorts of muck being cast around. You will find, especially in an area of social media, etc., you will find lots of posts being put up about a particular chap who has applied to become a judge. Lots of stinky stuff will be brought out from wardrobe, which may have nothing to do with his position as a judge, personal issues about his personal life and things like that. In the past, we have known this. In fact, in the Supreme Court where we practice, every time a judge is about to be sworn in, you find these leaflets finding themselves through the corridors, being sent to the judges, mentioning lots of
ill
things.
So you're saying it would be very difficult to deal with then?
I think it'll become
so, Anil
quite
Dewan,
onerous.
how do you counter that? How with the CV and everything put on the website as you're suggesting, how do you stop this kind of mischief that might happen?
May I respond to that? Should I respond to that? See, today what has happened, today's media reports say that 659 evaluations have to be redone for the subordinate judiciary, which was an exam which was taken by the Delhi High Court. And what was the allegation? The allegation was that favorites or persons related to judges were given a better chance than others. Now, if the Supreme Court has asked for a re-evaluation on the basis of this particular allegation, then is it not correct that while disclosing your CV, you should also disclose whether you are related to a sitting or a retired judge or a serving political leader or a retired political leader? I think the public should know this, because how do they judge later on whether the choice is right or wrong? And in every democratic country, you have a right to criticize. Now, bringing up muck and all that, I don't think is going to affect the judges, because if there is a complaint, you must substantiate with it material.
Manu, one quick statement in response. This is after the person applies. Think of what happens to deter good lawyers who want to apply for judgeship when they see this happening to others before them. They will say, look, I don't want to go through that. Things like you have a mistress, say, who is also a judge or who's a lawyer practicing in that court. You're not going to divulge that on an affidavit. That's not part of your CV. But it's something that people at the bar know, right? Or your close proximity with one particular lawyer or a judge. It's not a relationship.
But isn't it also about being public life? Don't politicians go through that? And shouldn't judges also embrace that?
Not to this extent. I'm saying what is relevant for them discharging their judicial duties, including the fact that they may be related to a particular person or have relations who are practicing in that court. So please don't have him as a judge in that court. Have him as a judge in some other court. Those things are relevant.
Okay, you know, a lot of these law students have a lot of questions. I just who wanted to go first? Yeah. Go ahead.
How can the government ensure meritocracy, accountability and transparency in the system, because that was lacking in the NJAC and that is lacking in the collegium as well. And what about the idea, since Devan sir brought up the issue of the subordinate judiciary, what about an idea for a national judicial academy?
Do you want to take that?
Well, we have a national judicial academy in Bhopal. No, well, judicial services. Well, I think that's a very good idea. But the only issue is that very often the skills that you pick up as a judge, you develop as you go on while you're sitting in court and figure out various areas. So, for example, if you're ever going to be, say, a Bombay High Court judge and retire only being a Bombay High Court judge, you have to know things like Admiralty law and things which are specific to Bombay, which may not be specific to Chhattisgarh. So, those kind of skill sets, it's kind of difficult to take it broad-based and create, I think, an entire legal service for the entire country.
Okay.
In my view, I think it's a little difficult.
I just want to go through some of the suggestions that the government had, which Attorney General Mukul Rohatgi said in court today. And I just wanted to ask both of you, and perhaps the students as well could, chip in, about which of these suggestions of the government is something that would be acceptable to the Supreme Court, do you think? First of all, them saying that the collegium should record reasons for choosing a judge. Mr. Devan, do you think this is something that judges will accept, putting their reasons for choosing a particular judge on paper?
I think some excellent suggestions have come from the government. One is a permanent secretariat, because this collecting a database for all the potential candidates is a very stressful exercise. So that's an excellent suggestion. Yeah, you must have a permanent secretariat devoted only to the task of gathering information, analyzing it, and providing a database. Second, if a question arises in future at some time, I think a recording of reasons is absolutely essential. And may I go back? Because somebody raised a question about disclosures. Now in the UK, full details have to be given as far as applicants are concerned. How far they are disclosed or not disclosed, I do not know. Similarly, in South Africa, you have to give a complete CV, etc. Now, how far they put it on a website, I have no knowledge. But I think, under Indian conditions, there is no harm in putting it on the website. Because if you don't want to apply, if you want to do public service, you have to face public scrutiny. Public service involves public scrutiny.
Yeah, Mr. Devan, I just wanted to go through some of the other things as well. There's criteria for judges should be made public. That's something you suggested as well. And that there should be a minimum eligibility for judges required. Is that going to be problematic?
I don't think that's problematic, but I think they need to revise a few things. You know, one of the provisions which is there in the Constitution for so many years is that if you're an eminent jurist of a certain level, you could be made a judge, right? Now, an eminent jurist, they seem to construe, particularly with reference to as a practicing lawyer.
Okay.
We have never had a full-fledged academic being brought to the Supreme Court, for example, and I've noticed this gulf between academia and the practice of law. So I think we should definitely, and Professor MP Singh also says this, you need to bring more academics into the judicial fold as well.
We're going to take a short break. When we come back, more questions and why Justice Dinakaran's case has become such a test case in this entire episode. We'll talk about that in just a bit. Stay with us.